Mr. Riley, would you please proceed?
Good morning, Your Honors. Mr. Chief Justice, may it please the Court, Robert Riley on behalf of Plaintiff Appellant NL Venture 6 Farmington, LLC. If I may, I'd like to reserve 4 minutes of my time for rebuttal, and I waive the initial free fire zone. This is a case of statutory interpretation of great significance to the state for 2 reasons. First, in a published Court of Appeals decision, that court erroneously interpreted and misapplied the meaning of the word shall in Livonia's city ordinance governing the enforcement of water liens, and held that the word shall is discretionary, such that Livonia could ignore the ordinance's requirements. That holding upends decades-old precedent of this Court and the Court of Appeals, and threatens the future interpretation and application of countless statutes that contain the word shall. The second reason this case is important is that by refusing to give effect to the plain language of Livonia's city ordinance, the Court of Appeals effectively called into question the applicability of every municipal enforcement ordinance and its place in the statutory water lien scheme. To address these issues, the Court requested the parties to brief 2 specific questions. The first being whether the Revenue Bond Act, the Municipal Water Liens Act, or any other authority exists to authorize the city's attempted enforcement mechanism in this case. The answer to that question is no. There is no such authority. The second question is whether the City of Livonia is prohibited from collecting the disputed liens because it failed to timely place the water liens, on the tax roll each year as required by the ordinance. The answer to that question is yes. Turning to the specific statutes at issue, the first is the Revenue Bond Act. That act provides a method by which charges for water service may be a lien on property. But the most important provision of the Revenue Bond Act for this case mandates that municipalities enact implementing legislation governing the enforcement of water liens. In other words, the Revenue Bond Act standing alone doesn't provide any enforcement mechanism for water liens. The legislature left that, in fact mandated that municipalities decide how best to accomplish that in their jurisdiction. So returning to the first of the Court's questions, the Revenue Bond Act doesn't provide any authority for the attempted collection method. With respect to the second question, because the Revenue Bond Act directs us to an implementing ordinance enacted by the City of Livonia, and the City admittedly failed to follow its ordinance, the Revenue Bond Act precludes Livonia from collecting on the disputed liens. That brings us to the Municipal Water Liens Act, which is broader than and cumulative to the Revenue Bond Act. And there are 2 provisions of that act applicable here. The first grants an automatic lien in favor of municipalities against properties to which they provide water, and that lien is good for 3 years. There is no dispute in this case. NL Ventures does not dispute that a lien attached to NL Ventures property. The second provision is the key provision, and that's whether that lien is enforceable. And the Municipal Water Liens Act provides 3 enforcement mechanisms for water liens. The first is through a city charter provision, the second is through a municipal ordinance, and the third is through the general laws of the state with respect to property taxes. Applying each of those here, it's undisputed there's no city charter provision applicable. So that mechanism is not at issue here. With respect to the ordinance, it's also undisputed that Livonia did not comply with its ordinance's requirements. So that enforcement mechanism is also unavailable. That leaves us with the general laws of the state of Michigan with respect to property taxes, the GPTA. To answer the Court's question bluntly, there is no provision in the GPTA that allows for the enforcement of a tax lien such that it can be collected as a tax. And that makes inherent sense because the Revenue Bond Act specifically delegated that responsibility to municipalities, and Livonia followed the legislature's mandate and enacted its ordinance governing enforcement. So we submit that the GPTA also does not provide any enforcement mechanism.
Counsel, I have a question, though. Wasn't your client aware of, even though it wasn't on the assessment, he was still aware, your client was still aware of the amount that they owed the city, were they not?
We were aware that Alry Bakery, our tenant, was in financial difficulty.
Right.
But we submit that we were unaware of the delinquent water bills. We knew they were in distress. That's undisputed. But we weren't aware of the specific water bill issue.
So, counsel, assuming we agree that this case has to go through the ordinance, that that's the enforcement mechanism, which seems to make sense to me. Otherwise, I'm not sure exactly what authority the city would have or a city officer would have to put this lien amount on the tax rolls. The question becomes why you believe the city's failure to follow the ordinance somehow rendered the lien invalid.
There's a subtle response to your question that I think is crucial here, and that's that the
Don't make it too subtle.
The lien itself was not invalid. The lien automatically attached. The legislature made clear that that lien is first in priority, and we don't believe that under the circumstances of this case there's any basis to destroy that lien. The question is whether that lien is enforceable as a tax, and there's only one statutory mechanism by which the lien becomes a collectible tax, and that's through placement on the tax roll, which brings us to the third piece, the ordinance, and that ordinance sets forth 5 specific requirements for transformation of the lien into a collectible tax. And each of those requirements is made clear through Livonia City Council's use of the word shall. None of those are discretionary.
So we're in a bail bond situation, whether that shall is mandatory or directory. Is that where you think we are on the analysis, or are we somewhere else?
Yes, we believe that the Livonia City Council had a choice of words it could use in enacting its ordinance. It could have enacted any number of schemes by which it could enforce these
I agree.
tax
I agree.
schemes. They chose.
I'm with you. Then for some reason, instead of following the language of the Revenue Act, which said may and then shall, they picked language that said shall and then shall. I'm with you. The question for us, though, is whether that's a mandatory shall. In other words, whether the requirement is that if they don't put it on the I think of the tax roll every year, that then they can't pursue the lien, enforce the lien, correct? Through the collection, through the GPTA, which is the way that this city collects its water and overdue water bills, correct?
That's correct.
So why do you think that shall? Is it just because of the nature of the word shall, or we have a whole sort of body of law, budding body of law that we've in recent years that tells us whether shall means shall in this context?
Yes.
Sometimes it does, sometimes it doesn't.
Right. And there's reasons for that, and this is an interesting situation because Justice Bernstein talked about notice, but as you mentioned, the Water Lien Act is very muscular for municipalities, and under that statute, notice is presumed. Under that statute, regardless of how the city tries to collect the water lien remains valid and enforceable. Shouldn't we be discussing what your client's private interests were here versus the public interest? Shouldn't that be some of the discussion in this case, or do you not believe that that's relevant?
All of the above are relevant. So first, addressing your question about the use of the word shall. We do believe that implies a mandatory requirement on the city. As I mentioned, the city could have chosen any number of words. It chose that one, and we think that choice was important because the city wanted to ensure that its property owners were made aware of these liens and whether they were going to be enforceable. Taken to its logical conclusion, under the Court of Appeals opinion saying that shall is effectively permissive, a property buyer could do their due diligence, conduct a title search, conduct a tax search. There's nothing on the title indicating that there are delinquent water bills. And as long as it's within the 3-year period, the city could come up later and say, hey, oh, by the way, we have these delinquent bills that we're now going to roll onto the taxes. But we didn't do it in the timely manner as required by ordinance. We're just doing it now because we decided that we don't like you as much as we like the last property owner.
What if the city had complied and done it in a timely fashion, complied under your vision of the statute? How would things be different? So, in other words, how was your client harmed by the city's putting these on the tax rolls later rather than earlier?
Well, they weren't aware that these these were even being they were unpaid.
Right. So I understand that. So what would you have done differently if you'd known? What would you have done? How would you be in a different position now if the city had done what you claim the city should have done?
As soon as those water liens were converted to a tax on the tax roll, we would have received notice that those were unpaid taxes. We could have had a conversation with our tenant, and if they weren't going to pay them, we would have whatever rights we have under our lease with our tenant, including but not limited to evicting the tenant so that they don't incur further water bills.
So your position is that the shall is there to protect landlords?
Yes, absolutely.
All right, so there's two problems that I see with that position. One we've already discussed, which is your client's already on constructive notice based on the Water Lien Act, correct?
They're on constructive notice of the lien, not whether the lien is enforceable as a tax.
What else would it be?
It's an interest in the property belonging to the city by virtue of the city having provided water to the property. Our assumption is under the lease that the tenant's going to pay its bill. Unless that bill or the lien is rolled onto the taxes, we have no notice that it's gone unpaid.
Well, but that just seems like something that you could have contracted around, right? So you know that the city has a lien on your real property the moment that they start providing you with water. So you want to lease it to somebody, you're concerned about whether that person's going to pay their water bill. Why don't you just require them to, as a condition of the lease, submit a receipt from the city, I don't know, monthly, quarterly, whenever it is that they pay their water bill? You could just contract around that problem, and you didn't.
You're correct. We could have contracted around that. But we're also relying on the express language of the ordinance that says the city shall do X, Y, and Z. It's actually A through E.
That's what we're trying to figure out, is why are you entitled to rely on that?
So let me ask a related question. So I'm not sure I can wrap my mind around the distinction between notice of the lien and notice of how the lien will be enforced, because your client also has at its disposal the means to learn that the city enforces its liens in this manner through the GPTA. But put that aside for the moment, getting back to the original question, which is your position is that shall in the ordinance was there to protect your client, right? And however, both of these statutory schemes from the 1930s seem to have provisions that are specifically designed to protect landlords by giving them the opportunity to provide certain notices and affidavits and so forth that they have a tenant and that they therefore will not be held liable for precisely this kind of obligation. So why aren't those, number one, I assume your client didn't avail themselves of those provisions or we wouldn't be here, but why are those not the protection in this whole statutory ordinance scheme that the legislature contemplated for landlords?
You're
and
correct.
Why aren't those sufficient?
We did not avail ourselves of the affidavit opportunity under 123.165.
Why not?
Hindsight's 20/20, Your Honor.
You weren't the lawyer then.
I'm never going to, my client is perfect. I would never suggest otherwise. That said, that defense is one defense that's available to the liens, and it doesn't otherwise excuse.
It's a pretty good one, right?
An apparently bulletproof one.
Right.
But that doesn't otherwise excuse the city's obligation to follow its enacted ordinance.
Well, it does if I'm trying to read our bail bond case and the law in this area and figure out, whether this shall was mandatory. I have to think about whether the shall was there, whether it was designed to protect your client in precisely this way. And since I have this other big provision that's bulletproof, that's designed specifically to protect your client in this way, it makes it less likely, I think, for me to conclude that this shall was designed for that reason. And I'm trying to get you to take that head on, because I think that's where sort of the action is in this case. Even though the bail bond issue wasn't really litigated below, it's sort of the trial court's decision sounds like a bail bond type decision, right?
Sure. So 2 points there. Legislatures are presumed to know the meaning of the words that they choose, and certainly we should give the Livonia City Council credit for choosing shall as opposed to may. May appears, at least in the Revenue Bond Act, so they're familiar that was one way that they could impose permissive obligations. And
this whole permissive or mandatory directory thing, the whole thing grew up because there's this notion in the law that when municipal officers make mistakes, we don't always want the public at large to be punished by those mistakes, right? That's why we sort of are asking these questions. It seems to me one of the big public interests here of the citizens of Livonia is to have these tax bills paid, right? So that doesn't have to, all the rest of the citizens don't have to pay for them. So that's like a big public interest question that's out there. And so that's, again, why I understand that it says shall. I know what shall means. I know how we've interpreted shall. But the question is, why here should we put, interpret shall as being designed to protect your client instead of thinking about the public interest?
We're not asking for any special treatment, Your Honor. We're asking that shall be interpreted the same as it is with respect to the city, who has said, and I think everybody agrees, because we didn't file the affidavit required by 123-165, which language says shall file the affidavit. We're asking that that word be consistently interpreted in the ordinance that Livonia chose to enact. I understand that my time is up.
I know, but I have a really important question. How can a water bill possibly get to $900,000? What were they doing, your tenant?
The tenant ran a bakery.
I know, but seriously, how do you get to $900,000? Were there like showers on all day long, 24 hours a day? How do you get a $900,000 water bill?
A lot of donuts.
A lot of donuts, yeah. Okay.
Thank you, Counsel.
I actually used to live with them.
Mr. Fisher?
Or not Starbucks,
Hi, I'm Michael Fisher on behalf of the City of Livonia. And this is the thing. If the notice on your windshield says, get your car off the street by noon, it does not mean that you can never move your car again once it gets to 12:01. Because that's a continuing obligation, and if you don't move it, we'll move it for you. That's the message of that notice. And this is sort of a metaphor for this case and moving the water lien onto the tax bill. Because if we don't move it in a timely fashion, the bondholders can come to court and compel us to do it. They have the ability under Section 9 of the Revenue Bond Act to do precisely that. Remember, the Revenue Bond Act is a statutory scheme to finance infrastructure by making revenue bonds attractive to purchasers by protecting bondholders. And a ruling against the city in this case would risk making infrastructure financing more expensive in this state. It would undermine the concept of you pay your own way for water and sewer bills and service. It would promote shutoffs as a means of enforcement if you undermine this alternative means of enforcement. And I think it violates the plain language of the statutes and the ordinance. And I'll explain how. The Revenue Bond Act says it is cumulative, full and complete, additional alternate grant of power and methods of exercising those powers, which includes the ordinance. This ordinance was clearly adopted pursuant to the Revenue Bond Act. So there's one bag, self-contained bag of procedures and powers that is the Revenue Bond Act. The plaintiff in this case wants to add a now or never provision to the ordinance, which it doesn't actually say. It doesn't say you shall or else you lose the ability to ever enforce these liens. And, as Justice Cooley said way back when, you never assume that it's now or never. You only provide, that only comes into play if you have either a hearing date or something of value that you're depriving the person of by not meeting the deadline. As this court has already observed, there is nothing important that we've deprived this plaintiff of. The statutes don't provide for a hearing. He has statutory notice. There is no right to free water. He slept on his right to stop the liens from accruing or to end the accrual. So following the plain language of the ordinance, there's no reason to say that they have any right to stop this lien from being enforced at this point. The second plain language issue is the Municipal Water Liens Act, which clearly identifies itself, and counsel has acknowledged that it's another separate set of procedures from the Revenue Bond Act. And it provides that the lien can be enforced through the General Property Tax Act, as we've discussed. What the plaintiff is arguing is that...
I have a question, though. What should a landlord do? I mean, we've heard kind of the situation of the plaintiff, but what should they do? What would you want a landlord to do? Like if I own a shopping center, if I own a large facility, how am I supposed to know exactly if I don't have if I'm not able to see what the tax rolls say, how am I supposed to surmise what my tenant is doing if you're not going to tell me until after a number of years?
Well, actually, this is a problem with using your tax bill as a source of notice. Because bear in mind, this is only going to happen one time a year. You're going to get your quote-unquote notice on December 1. And then you'll get no notice until the next December 1. The second problem is, though, because of the 6-month rule in the Revenue Bond Act, no arrearage that's shorter than 6 months or that's less than 6 months ever shows up on the tax bill anyhow. And that's part of how you get to $900,000 in your arrearage is you have, as long as you stay within 6 months, it never goes in the tax bill anyhow. And so that's why this wasn't on the tax bill in 2009 or 2010, because there weren't 6-month-old arrearages at that point. That doesn't happen until 2011 when RE asks for the relief and the Water and Sewer Board gives it to them for 1 year. But what this means is the 6-month rule guarantees that you'll see no arrearage that's less than 6 months old, and depending on when the arrearage starts, it could be as much as 18 months old by the time you see it. And in fact, because the Livonia ordinance used March 1 as a trigger date and December 1 as the tax bill date, it's actually more like 9 months as a minimum in Livonia. So this is how you can have arrearages run up and they will not get noticed. And they're crazy if they only wait for that 1 year notice, especially in a situation like this where they're hemorrhaging cash, where RE's hemorrhaging cash. And in fact, the lease that they signed with RE did provide that RE had to provide them with proof of payment of the water bills. They just didn't enforce that provision of the lease. So I think the answer to your question is, number one, you can't sit around and wait for the tax bill to come. Number two, you can tell RE, okay, prove that you're paying the water bills. And number three, you can also go and just look. I mean, really what the statute means when it says you're on notice of the records at the municipality is go look, ask. Don't sit and wait for the tax bill to come.
So why didn't your client comply with its own ordinance?
Well, that was because
you get to dictate the terms of the ordinance, right?
Right. Well, and what I was going to say about this was the Municipal Water Liens Act, being a separate set of procedures, says we can use the General Property Tax Act without reference to this ordinance.
You don't seriously contend that.
I absolutely seriously contend.
So Hal at the city sitting at the front desk can just say, hey, you know what, it's Wednesday. Why don't we put this on the tax rolls?
Well, we
it's been
don't.
long enough. I waited 3 weeks. He hasn't returned my phone call. We're going to the tax rolls.
We don't do that because
well, under
number one, we don't want to
case you could, right?
Well, but we don't want to be sued for everything we do, frankly.
But why would you be sued? Under your theory,
you can do that.
Well, because whether we win or lose, we get sued, right? So, I mean, we're not trying to be in litigation every day about the procedures. So we follow, and besides that, there's some internal administrative value to having your.
You're making the legal argument, so I'm just trying to follow it. And
okay, sorry.
That's okay. You believe that the statutes. Did they give you that right or not? That even the lowest level clerk at the city could just call over to the county treasurer's office and say, put this on the tax rolls? There's no procedure that they have to follow?
Well, let me say this about that. There are 3 other statutes that I called the court's attention to when I was briefing out. I don't expect you to remember them. But there are 3 other statutes that do the same thing, that allow municipal fees to be enforced through the GPTA. One of those is the Housing Law of Michigan, which says if you demolish a dangerous building, you can put that cost on the tax rolls. Another one is there's the Natural Resources and Environmental Protection Act provides for if we go and do erosion control on a piece of property, we can put those expenses, we can enforce those expenses via the GPTA. And there's the third one is the noxious weed statute that says you can basically cut down overgrown properties. And again, you can take that cost and enforce that through the GPTA. None of those statutes say anything about it has to go on the tax bill, but that's the way we always regard that. And I think
and you don't have an ordinance in Livonia on any of those subjects?
Well, there are ordinances on those subjects, but they don't. They all follow the state in saying, okay, we can enforce this through the General Property Tax Act, and we regard the right to put those on the tax bill as necessarily implied by the ability to use the GPTA to enforce anyway. Otherwise, it's meaningless. And the statute doesn't say in any of those cases does not say anything about tax bill or anything like that. I mean, it just says you can enforce through the GPTA. So consistent with the construction of those statutes, we think this statute means we can enforce these via the GPTA. Again, why we don't want to do the 1 week arrearage.
Why did your city waste the time drafting this ordinance?
Well, I don't think
put all this extra restriction on yourself.
I think the Act 94, or Revenue Bond Act, and the Municipal Water Liens Act are essentially redundant systems designed to protect these liens and ensure enforcement of water. Because remember, I mean, we're not enforcing these for the sake of the plaintiff. We're enforcing these for the sake of the other ratepayers and for the bondholders. And those are the people who get hurt if the city doesn't, if the ruling goes against the city in this case. But specific to your question about why do we do the
Don't businesses
ordinance?
but at the same time, though, like I hear your policy argument, but don't businesses and landowners kind of get hurt too, because you're putting them in a situation where they're kind of holding themselves out to things that are unknown in certain. I get your argument, you can go check and things of that sort, but isn't it fair to say that there's still, if you're making the policy argument that you're putting the entire kind of large, you're putting the entire public works at risk by this case, then doesn't that ultimately follow through that you need to follow your own ordinances better?
Well, I mean, maybe you could argue that they were wrong to give RE the relief they requested. I won't dispute that. But I think it's still true that to the extent you're talking about landlords, they have the absolute right to stop the lien accruing from them right now, anytime they want. All they have to do is file the tenant responsibility notice, which was never done in this case, which is also part of how this got to be such a big arrearage. Landlords specifically.
So is that your position, that if I'm a landowner and I'm a holding company and what have you, and I'm a landowner, that I need to be checking all the time what my tenant? I mean, this is my responsibility as if I'm a large kind of holding company. It's my job now to kind of go through and see exactly what every one of my tenants is doing, and then make sure that I know that they're not in arrears, because 3 years later I could get hit with a $900,000 bill that I was not expecting.
Well, remember, you as the landlord have the absolute right to stop that lien from accruing anytime you want. So you don't have to.
But my question to you is, is it my responsibility to be aware of it? That's my question. Like, is it my job as a landowner? Do I have to be? Is this my new responsibility now that I have to be aware of this lien?
I don't think it's a new responsibility. The statute says you're on notice.
I get that, but I'm going to see it if it comes through the tax rolls. But what I'm saying here is that I just think it's hard for business. I mean, you made your policy argument about bondholders and things of that sort. I totally get it. My question back to you is, if I'm a business owner, is this now a new responsibility that I have to adhere to in order to see exactly what's happening? The idea is, large businesses, or like people in this situation, are getting. Isn't it fair to say that they could get caught by surprise?
Well, they shouldn't get caught by surprise. This is a sophisticated real estate entity. They have the absolute right to go and look and ask what the water bill is if they're not. If they don't know the answer to that, they under their lease, they also have the ability to demand proof of payment. And besides that, like I say, they can stop the lien from accruing anytime they want. They've slept on their rights to do that. Anyway, one thing I would add is, if they are for any reason inclined not to just affirm the Court of Appeals, the Circuit Court made the mistake of not only throwing out the untimely liens, but throwing out the timely ones as well. So I'd ask that whatever you do, please do not just affirm the Circuit Court with your decision. But yes, I think if this case goes against us, it gets harder to finance, or potentially more expensive to finance infrastructure in this state, because one of the protections that the Revenue Bond Act gives bondholders is that you have an exclusive right to go to court to enforce and protect bondholders' interests.
But could it also result in cities and towns having to follow their own ordinances stricter and better so that people won't be caught off guard?
Well, the reason that there's an idiot-proofing provision in the Municipal Water Liens Act that says these liens can never be invalidated or waived is precisely because there's the concern that sooner or later somebody will make that blunder. And in this case, they didn't even think they were blundering. They thought they were doing something good, trying to help RE over the rough spot. And their punishment for that is, okay, now you can't enforce the lien anymore.
So who took the risk? The landowner, RE, or the city?
Well, the landowner takes the risk when he doesn't file that tenant's responsibility.
But the landowner didn't even know about it.
Yes,
I understand the argument that that you're saying he should have known about it. What I'm saying is that the person that's basically, you had the city that was trying to kind of induce the bakery. the bakery that was trying to get a good deal from the city, and then you have the third party, which is the landowner, who is kind of the person who isn't really a part of any of this, who is now the one that has to pay for all this. So you have two people kind of entering into an arrangement or a contract, and a third party who really wasn't privy to any of it, who is now having to absorb all the responsibility.
Well, he absorbs the responsibility because the legislature chose that outcome, not because any of us chose it or imposed it on him. They chose not to stop the lien from accruing. They chose not to go and ask.
Maybe shouldn't the city have included the landowner in the conversation if you were going to try to make this arrangement? Why didn't you include the landowner?
I have no idea. I had no participation in that at all. But we don't have any duty to the plaintiff in this situation. Our duties are to the bondholders and to the other ratepayers, and we're trying to collect the best way we can to respond to those duties and to serve those people.
Okay, thank you very much. The case is submitted.
Thank you, Your Honor.
We will recess now until approximately 12:15.